So this video will talk about Unit 9 of Admin Law in regards with public interest immunity and state liability. So before we start, I wanted to make something clear. That is, the purpose for this video is to summarize the unit. And I may be wrong in some areas, or I can miss a few things here and there. So you're encouraged to correct me where you think I've made a mistake. And regardless, good luck with tomorrow's paper, and I hope you guys all the best. So before we jump into public interest immunity, we must first understand what discovery is in relation with admin law. So in admin law, a discovery refers to the process by which parties involved in an administrative proceeding exchange information and gather evidence relevant to the issue being adjudicated. So, in order to establish the liability of a party to an action or to establish one's defense to an action, it is necessary to request documentation from the opposing party. So that's what discovery is, just the exchange of information and evidence relevant to the case. So now that we have a general understanding of what discovery is, we can now jump into public interest immunity. So this was previously known as Crown privilege, and it's an exclusionary rule of evidence. So this is a legal principle that allows the government or public authorities to withhold certain documents or information from disclosure in legal proceedings. So like if revealing them would harm public interest. So under this principle, the court balances two compelling interests, thus the need for justice by ensuring fairness in legal proceedings by providing access to all relevant evidence, and second, the public interest in confidentiality, that is protecting national security, sensitive government operations, or the safety of individuals. So the court decides whether the harm from disclosure outweighs the need for transparency in the case, as was seen in the case of Michael Sata versus Sports Newspapers and others. So what happened in this case was that the court ruled on a matter involving public interest immunity and disclosure of documents related to investigations by the SEC. So the court upheld the Attorney General's objection to disclosure, citing the importance of protecting the Commission's work and public interest. The court emphasized that public interest immunity cannot be waived and that the court has a duty to consider the issue even if the parties do not raise it. The court set aside the summons to produce the protected documents, upholding the Attorney General's objection. And we also have the case of Duncan versus Camel Laird. So this case established two grounds in relation to public interest immunity. The first is the content ground, that the contents of the document for which the privilege is claimed demand that the document not be discussed as being injurious to public interest. And the second is the class ground. So in this ground, it states that the class of document, the contents of which per se would not merit a claim of privilege, belongs to a class of documents which must not be discussed in public interest. So the brief facts of this case are that relatives of those who had died in the sinking of a submarine during sea trials sued the shipbuilders, alleging negligence and seeking disclosure of technical defaults about the submarine's design. So the British government objected, claiming that the releasing of the documents would compromise national security. The House of the Lords upheld the government's claim of Crown privilege, now known as public interest immunity, ruling that the documents should remain confidential to protect state interests, even at the cost of withholding evidence in legal proceedings. So the background of this case was that it was during World War II, where Britain was actively engaged in the war. So this context heavily influenced the court's decision to prioritize national security over disclosure. There was a need to protect military and naval designs during wartime. As such, the disclosure of those documents was denied. So now we'll look at the modern application of public interest immunity. So there are issues to be addressed in consideration of modern application of public interest immunity. We have 7 of them, and the first one is who hears a claim for privileges. So claims for public interest immunity are usually heard by the courts, and the judge must determine whether the claim for immunity is justified. So courts do not automatically accept government claims, but will examine the context and necessity of withholding the documents. You can also put that case for Duncan and Camille Leard for like this one. Then number 2, we have for what type of document might immunity be claimed in the class ground. So public interest immunity can be claimed for documents that relate to national security, defense, or sensitive government operations, as was seen in the Duncan and Camel case again. Then the third one is who can make a claim for immunity. So government ministers typically have the claim for immunity. In some cases, this claim might also be made by officials acting on behalf of the government, such as civil servants or law enforcement agencies when the issue concerns national security. Then the fourth issue is who determines public interest. So the courts are responsible for determining public interest, while government ministers may assert that disclosure would harm the public interest. The judge has the final say. Then the fifth issue is, can a claim for immunity be made in the context of a criminal trial? So yes, it can, but however, the court will need to weigh the importance of the evidence in the trial against the public interest of withholding it. Then the sixth is, does a minister have the power to claim immunity? So yes, a minister can, and they have the power to claim public interest immunity, but they are not under a absolute duty to do so. So the minister must make a judgment about whether disclosing the information would harm public interest, but the courts have the power to assess whether the claim is valid and whether the public interest immunity should apply. And the seventh and final issue is, can immunity be waived? So yes, public interest immunity can be waived by the party asserting the immunity. This can happen if the government decides that the public interest no longer requires non-disclosure or if the circumstances change. So the courts may also find that a waiver has occurred implicitly. For example, if the government discloses part of the information that has been previously protected by the law. So in general, these issues reflect the modern application of public interest immunity in legal proceedings, balancing transparency, justice, and national security or confidential interests. So now we'll look at for what types of documents can immunity be claimed on the clash ground. So according to the case of Duncan versus Canel, Leonard, whatever, public interests would justify a claim of privileges on the class ground where disclosure would be injurious to national defense and where disclosure would be injurious to good diplomatic relations and where non-disclosure was necessary for the proper functioning of the public service. So according to the case of Chilwa versus the Attorney General, immunity acts as a shield against prosecution and not investigation. So the brief facts of the case of Chilwa versus the Attorney General are that Chilwa was involved in a corruption case, and the Attorney General sought to withhold certain sensitive government documents, citing national security. The Supreme Court ruled in favor of Chilwa, emphasizing that the government could not automatically assert immunity without judicial review. The court held that the claim for public interest immunity had to be assessed based on whether withholding the documents served the public interest, ensuring that Chilwa's right to a fair trial was protected. So with that, we have covered Unit 9 of Admin Law. We have talked about discovery, public interest immunity, and the relevant cases in this topic.